Have you received an eviction summons and complaint? I'm Alejandra Aguilera, and I'm the founding attorney of the Aguilera Law Center. I'm going to talk about the eviction process. It's important to note before we start that the eviction process only entails, what I'm going to talk about only entails residential evictions. So commercial and office spaces, though that's an area of law that's different. Residential is under Chapter 83 in the Florida statute. So it's separate, residential versus commercial. I'm going to talk about residential evictions in Florida, and specifically my experiences with Miami evictions. But in any case, it's the same Florida law applies in any county as to residential evictions. Florida law requires written notice before filing an eviction. In order to get more information, you can read through my blogs as to the specific requirements under Florida law, but it is highly suggested that landlords and tenants consult with an attorney that has experience in landlord-tenant law, because Florida law is very specific as to the language in a written notice and as to the defenses that a tenant has in an eviction process. So each case is different, and I would highly suggest that once a tenant receives a summons and complaint and they have questions, they need legal advice, they should consult an attorney. The Aguilera Law Center has practiced landlord-tenant law for several years and has experience in those areas of law. And so I'm going to talk about the different areas in the eviction process. The first area is that written notice that is required. Once the written notice is delivered to the tenant is now put on notice as to the allegations or the alleged violations and the basis of the eviction. The second part is going to be that the tenant is going to have to receive the eviction package from the court via personal service. So the tenant has to be served the eviction complaint and the summons. The summons is going to explain the important rules involved that a tenant, and that most tenants don't read this, but the tenant should know that you have 5 days to file an answer. 5 days from the point that you receive that eviction complaint. It does not include holidays and it does not include weekends, but you have 5 days. If you file it on the 6th day, you file your answer on the 6th day, the court may not accept it and the landlord may automatically win. It would be a default because you did not file your answer within the 5 days provided. Another requirement for the tenant after filing a response or answer in those 5 days, they must deposit the rent into the court registry. The court registry must have the rent within those 5 days. If you're not depositing the rent because let's say you already paid the landlord the rent due and you have proof of that, then you make sure that you file a motion to determine rent, and this motion will basically notify the court that you have already paid or whatever the circumstances are as to why you're not paying the rent. But the motion to determine rent has a purpose in that it asks the court to determine how much rent to deposit into the court registry. But if you do owe some rent, you need to deposit that. It is highly suggested because if you do not do that, most courts will automatically issue a final judgment against you and you will automatically lose your case. So you have to file your answer within the 5 days and also deposit your rent or file a motion to determine rent. Now, after the 5 days and you filed the motion or you deposited your rent, you also filed your answer, and if you have any affirmative defenses, it's going to be in your answer. Once that is done, the court will usually schedule mediation, and at mediation, the two sides, the landlord and the tenant and their attorneys, if they have one, will be in an informal session where you have an independent mediator and you talk back and forth and try to resolve the case. At mediation, if you do not accept any offers of settlement, if there is no settlement at mediation, you will go to court again, whether it's for trial or for the court to make a determination as to any pending motions. But the next step would be to go to court, and at some point you're going to have a non-jury trial, or it's going to be a jury trial. You can request or demand a jury trial within the 5 days of your answer. So that's very important to also understand that when you file your answer, if you do want to have a jury trial, you need to ask for it within the 5 days of receiving your summons and complaint, or you lose that right.